Swayam Prabha. Digital India. Educated India.
Well, students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU. Today, I am going to discuss my 31st lecture, that is Emerging Dimensions of Human Right. So, you just look at your screen. I have highlighted various aspects of human rights. So, in this lecture, I would like to focus on emerging dimensions of human rights. You all might be knowing that human rights under UDHR 1948, right to equality. This Universal Declaration of Human Rights 1948 talks about equality. All the human beings are equal by birth. So, that equality we have incorporated under Article 14 of the Indian Constitution. Right to life. All the human beings have right to live with human dignity. Article 3 of UDHR 1948 talks about right to life, and Article 21 of the Indian Constitution talks about right to life as a fundamental right. So, you can just make this UDHR 1948. A right against torture or inhuman treatment, Article 5. A right against illegal arrest, Article 5 UDHR. A right to fair trial, Article 15 of the UDHR. So, why I have chosen only few human rights of UDHR 1948, so that I can explain you that from these human rights, Indian Supreme Court has given new impetus to Article 21 of the Indian Constitution, has given new impetus to fundamental rights in Indian context. Emerging dimension of human rights, for example, right to food, right to education, right to shelter. So, Supreme Court has widened the scope of Article 21 of the Indian Constitution, right, which is right to life or personal liberty. So, you see this Article 21 of the Indian Constitution says that no person shall be deprived of his life or personal liberty except procedure established by law. When this fundamental right was guaranteed under Article 21 of the Indian Constitution, the main assumption, assuming that under Article 21 every person has right to live with human dignity, but that Article 21 was not more clear about what are those essential requirements which can make life of a people better. So, Supreme Court, considering the gravity of life, has widened, strengthened the scope of Article 21. For example, that right to life would be meaningless for those poor people who are unable to manage their food, people are dying due to hunger, they are not in position to manage food. People who are unable to engage their counsel, advocate in the court of law due to poverty, they are unable to engage lawyer, counsel. So, that fundamental right would be meaningless for those people. If people do not have their shelter, if they are sleeping in open sky, then this fundamental right would be meaningless for those poor people. So, considering all these relevant factors, Supreme Court has widened the scope of right to life, and right to life includes all the things, bare necessities which are essential for the survival of human being. For example, fooding, clothing and shelter. These are three basic requirements of human being: food, shelter and clothing. So, Supreme Court, I will try to explain those judicial pronouncements where Supreme Court has widened this scope of right to life. The first thing which you can see on your screen, that is right to food as a human right. You see this right to food, food being essential component of life. So, poor people who are unable to manage their food due to poverty, they are allowed to die. State may allow them to die, or state should come forward to provide food free of cost. Since state has taken responsibility to save life and limb of its citizen, so it is the state responsibility to protect life or limb of its citizen. So, for that reason, the people who do not have sufficient means, sufficient money, they cannot manage their meal, it is the duty of state to provide food so that they can survive. So, Supreme Court for the first time in PUCL vs. Union of India AIR 2002, Supreme Court held that right to food is essential component of right to life. That right to life would be meaningless for those poor people who are dying due to starvation, due to hunger. So, starvation death is just like a blot for a democratic country. So, where country like India, where India is exporting food grains to other countries, India has become independent in producing food grains. FC Food Corporation of India has huge amount of food grains, and in spite of that, Kalahandi, Kyonjhar and Mayurbhanj district media has reported that many people they have lost their life due to starvation, due to hunger. So, Supreme Court said that if any starvation death is found in a particular state, it would be the responsibility of Chief Secretary of State to ensure that not a single death from starvation should be reported. If any starvation death is reported from any particular state, Chief Secretary of that state would be responsible, being Chief Administrative Officer of that state. So, this is a good initiative taken by Supreme Court in this case. You see, this case was decided by Supreme Court when PUCL, a non-governmental organization NGO, PUCL filed a petition before Supreme Court by highlighting the plight of poor people who were dying in 2000-2008. Media reported that Odisha is the poorest state in this country. So, Supreme Court took the cognizance and held that this right to food is essential component of Article 21 of the Indian Constitution. So, this is one aspect of Article 21 of the Indian Constitution. Now, come to another aspect of Article 21 of the Indian Constitution, that is right to shelter as a human right. So, every person has right to live with human dignity, and a person who does not have roof, shelter, people are sleeping in open sky, then it would be very humiliating for any democratic country, that where a country is unable to provide shelter to its people. So, this fundamental right would be meaningless if poor people they do not have their own roof, they do not have their own shelter. So, it is the since directive principle of state policy clearly talks about that state shall endeavor to provide nutritious food to its citizen, state shall endeavor to provide decent livelihood to its citizen, decent shelter to its citizen. So, directive principle of state policy part 4th of the Indian Constitution has imposed obligation upon Parliament, state legislature to make such a law, so that poor people may be provided accommodation, shelter. Otherwise, that right to life would be meaningless for these poor people. So, Supreme Court for the first time in Chameli Singh case versus State of UP held that right to shelter is essential component of Article 21 of the Indian Constitution. So, without shelter we cannot imagine the real existence of Article 21 of the Indian Constitution. Without providing shelter to the poor people, we cannot imagine a decent world, we cannot imagine India as a democratic country, because Indian Constitution, which talks about right to life, which has guaranteed right to life under Article 21. So, poor people who do not have sufficient means to manage their own house, government should come forward to provide shelter to the poor people. So, for that reason, since then you might have seen that government, central government as well as state governments, they have been providing housing scheme for poor people like Pradhan Mantri Awas Yojana, Balmiki Awas Yojana. So, government has started providing housing scheme, welfare scheme to the poor people. So, that is because of that judicial intervention which Supreme Court has intervened in this case. Now, come to this another aspect of right to life. That right to life would be meaningless if people have no access to education. If people do not have access to the education due to high cost of education fee, then it would be meaningless for them to live with dignified life. So, in order to provide, in order to ensure dignified life, Supreme Court said that primary education should be considered as fundamental right for those, particularly for those people who are unable to send their children to the school due to poverty, due to social constraint, due to financial constraint. So, Supreme Court in Mohini Jain versus State of Karnataka AIR 1992, you just can see on your screen that in Mohini Jain versus State of Karnataka AIR 1992, Supreme Court held that right to primary education is essential component of right to life. That right to life also requires a dignified life, and a life cannot be considered as dignified life if people are not educated, if people are not provided education free of cost, particularly those people who do not have sufficient adequate means to provide education to their children. So, Supreme Court in this case has held that right to primary education is a fundamental right, and it is the duty of state government to provide education free of cost. Since then, you might have seen that every state government has started providing free education to the children of their states. So, and Parliament has enacted special legislation Right to Education Act 2009. So, Right to Education 2009, that act is an outcome of this judicial pronouncement. Parliament has enacted that special legislation just to provide the education to the children of this country, and you all might be aware about Article 15 clause 3. It is specifically mentioned in Article 15 clause 3 that state can make special legislation for women and children, and state here means parliament or state legislature. So, parliament has made special legislation for the betterment of Indian children. The name of that legislation is Right to Education Act 2009. Every school, whether school is private owned school or government owned school, every school, government as well as private school, will have to provide education free of cost to those children who are having BPL card, they are below poverty line. So, it is the responsibility of that school to take their admission free of cost. So, otherwise it would be violation of their fundamental right guaranteed under Article 21 of A of the Indian Constitution. As you might be aware about Article 21 A of the Indian Constitution, which talks about primary education. So, Article 21 it says that every child who is above 6 years and below 14 years shall have right to get education free of cost if they are poor. So, government will have to provide education free of cost. So, primary education as a fundamental right, we are talking about new emerging dimension of human rights. So, you see how right to education has affected Indian democracy, and Supreme Court recognized this right to primary education as essential component of Article 21 of the Indian. Now, Come to another aspect of dignified life, Article 21. Life cannot be dignified if people are allowed to die due to lack of medical aid. So, medical aid is essential component in order to save the life of people of this country. So, medical aid is also essential component of life. No person, means life of person cannot be saved if people are allowed to die. Private nursing homes, medical hospitals, they are charging huge amount of medical expenses, and poor people are unable to pay huge amount of medical expense, they may die. So, whether question is whether they should be allowed to die, or government, it is the responsibility of government to save the life of those poor people. Ultimately, Constitution itself permits the government, mandates the government that central government as well as state government will have to take care of poor people, and medical assistance must be provided to the poor people on the cost of the government. Government will have to come forward to provide medical assistance. So, for that reason in 1989 you just see on your screen, in 1989 Supreme Court, in this case Paramanand Katara versus Union of India, AIR 1989, held that medical aid is essential component of Article 21 of the Indian Constitution. If people are allowed to die due to non-fulfillment of medical legal case, so it would be a case of medical negligence also, and still legal due to medical legal cases. So, in 1989 Supreme Court for the first time held that government hospitals as well as private hospitals must provide medical assistance, first aid, first medical aid to the victims injured in any accident without following legal medical case. You must have seen that if any accidental case is brought at the hospital, hospital authorities, doctors, they ask you to fulfill a form, that is medico legal form. Doctors, medical nursing homes, they have apprehension that if they will not, if patient will not fulfill this form, you can suit him, you can initiate any proceeding against hospital or doctor. So, doctors or hospital, for the sake of their benefit, they give you a form, you just put your entire information in this, how did you sustain this injury, who attacked you, who has assaulted you. So, all these kinds of formalities are to be done by the injured person or relatives of the injured person, and only then hospital allow you to admit, to take admission in that hospital. So, Supreme Court said it is bad. Supreme Court said that it would be wrong if any hospital, private or government, is found to complete this formality and person dies during completing these formalities, then that doctor, that hospital, private nursing home would be held responsible for criminal act. So, you see how Supreme Court intervened, how Supreme Court has made an effort to make life of people better. So, earlier before 1989, you might have seen, even still today in many hospitals which do not know about this Supreme Court guidelines, they ask you, if you go there, then they will ask you that you fulfill this application, only then I will take your admission in this hospital, otherwise I will not take your admission in this hospital. You see, they are bound to take your admission in the hospital without making any formality. Either they are private nursing home or they are government hospitals, they are bound to admit a patient who is injured without following any formality, without completing any formality, medical legal formality, because it has been seen that many people they die during the completing that formality. So, that formality is not required, and this Supreme Court said that right to medical aid is essential component of Article 21 of the Indian Constitution. Now, come to this, since I have chosen this topic, emerging issues of human rights. This is another important aspect of dignified life. A person cannot live with dignity, with human dignity, if that poverty comes within that man and getting access to justice. So, a person who is unable to access to justice due to poverty, due to financial constraint, so that right would be meaningless. All the fundamental rights would be meaningless for that poor person who do not have access to the court, who do not have access to the justice. So, for that purpose, Supreme Court held that it is the duty of state to provide free legal aid. It is the duty of state is constitutionally obliged to provide legal aid free of cost, particularly those people who are poor, who cannot manage advocate fee. So, you can see on your screen that right to free legal aid, how this right to free legal aid has emerged as a human right. It has emerged as a basic component of right to life or personal liberty only because of judicial intervention. You see, in this case Khatri vs. State of Bihar, AIR 1980, Supreme Court recognized this right, where an accused is languishing in jail for more than the period for which he has not been charged due to poverty. If it would be violation of his fundamental right guaranteed under Article 21. So, now I would like to give a brief history of this right to legal aid, fundamental right, how this right became fundamental right. You see, this right to free legal aid, it was recognized as a fundamental right in M.H. Hoscott case. Supreme Court in M.H. Hoscott versus State of Maharashtra, AIR 1978, for the first time recognized that right to free legal aid is essential component of Article 21 of the Indian Constitution, where poor people do not have access to the justice, right to life for them would be meaningless. So, it is the duty of government to provide legal assistance free of cost. Secondly, Supreme Court in Khatri vs. State of Bihar, AIR 1980 Supreme Court said that it is the duty of government to provide a counsel right from the arrest until the completion of the trial. So, that right to free legal aid was given more clarity by Supreme Court in this case, in Khatri case. In M.H. Hoscott vs. State of Maharashtra, Supreme Court recognized right to free legal aid as a fundamental right for the first time. There is no doubt at all. If you are asked, many times you might have seen that in PCSJ pre-examination, in IS pre-examination, it is asked that in which of the following cases Supreme Court for the first time recognized right to free legal aid as a fundamental right under Article 21 of the Indian Constitution. The name of case would be M.H. Hoscott versus State of Maharashtra. On the other hand, if it is asked that in which case Supreme Court for the first time held that right to free legal aid is available not only at the time of trial, but it starts that right to free legal aid, it starts right from the investigation till the completion of the trial. The name of case is Khatri vs. State of Bihar, AIR. In Khatri case, as I said, all the 34 accused to whom police made blind prisoner, Bhagalpur blind prisoner case, under trial prisoners, they were poor. So, Supreme Court said that they must be provided counsel, advocate, right at the time of interrogation, at the time of trial, till the trial ceases, completes. So, that right must be continued from investigation to. Now, come to this another important feature of emerging issues of human right. This is protection against handcuffing. Now, police are directed not to arrest any person in this manner, in this way. Supreme Court has made this remark in a case Prem Shankar Shukla versus Delhi administration. Firstly, I have highlighted protection against inhuman treatment, that is a human right. Every human being has right to be treated humanly. If a person against whom bad treatment or inhuman treatment is given by police, it would be violation of their human right guaranteed under Article 5 of UDHR. So, protection against inhuman treatment, ill treatment, that is a human right, that is a basic right. So, every person, every human being deserve good treatment, humanly treatment. So, where police officers they arrest any person and they handcuff. So, handcuffing is prohibited, and this handcuffing is prohibited because of that principle every person is presumed innocent unless his guilt is proved before the court of law. So, every person is presumed to be innocent unless his guilt is proved before the court of law. Because of this presumption of innocence, a person who has been arrested by the police cannot lose his precious right merely because of detention. So, he is still a human being. So, he must be provided all the benefits which he could have claimed as a common man. So, except few fundamental freedoms. So, in this case, in Prem Shankar Shukla case, Supreme Court for the first time held that protection against handcuffing is a fundamental right. Protection against handcuffing is essential component of Article 20 of the Indian Constitution, and police officer at the time of arrest cannot put any person on bar fetters or handcuff unless there is apprehension that he might abscond, that accused might abscond. So, you need to remember two things: right against handcuffing is a fundamental right, this is one aspect. On the other hand, police officer can also put an accused under this category, handcuffing or bar fetters, if there is apprehension that accused might abscond. If there is a possibility that accused might abscond, may abscond from the custody, then in that case police officers they are empowered to put any accused on bar fetters or handcuffing. But you see, in Sunil Batra case, Sunil Batra was a Delhi administration, Supreme Court for the first time held that protection against inhuman treatment, that is a constitutional guarantee. What happened in Sunil Batra case? Sunil Batra, he wrote a letter to a judge of Supreme Court by highlighting the plight of his by one inmates of the Tihar prison, and in that letter he had highlighted that jail superintendent and warden of the jail, they used to commit violence against an inmate of the Tihar prison. So, inquiry was conducted and Supreme Court found all the allegations true, and Supreme Court in this case held that since India too is a party to that international agreement, wherein India has expressed a desire to follow international commitment, and Article 5 of Universal Declaration of Human Rights, which is a guarantee against inhuman treatment, against illegal arrest, against illegal detention. So, India has given consent to fulfill international commitment in 1948, then India is bound to respect the right of prisoners also. So, Supreme Court for the first time held that right against inhuman treatment is violation of fundamental right of Article 21 of the Indian Constitution in this Sunil Batra case. So, I think you all must remember these two important cases where protection against handcuffing was declared unconstitutional, has been declared violation of fundamental right. Now, come to this compensatory jurisprudence, right to compensation. How this right to compensation has become essential component of dignified life, right to life or personal liberty. This right to compensation, every victim has right to get compensation from the wrongdoer if he or she has suffered injury or loss. So, there are three important case laws, you can see on the screen. I have referred three important case laws. First is Nilavati Behra versus State of Odisha. This is compensatory jurisprudence. Rudal Shah case, State of Bihar, Bodhisattva Gautam, Subhra Chakravarti. So, with the help of these three important judicial pronouncements, right to compensation was recognized as a fundamental right. So, how you see how this component has emerged as a human right, right to compensation. You all need to remember Article 3. Article 3 of Universal Declaration of Human Rights, which talks about right to live with human dignity. Article 21 of the Indian Constitution talks about right to live with human dignity. So, Supreme Court for the first time in Rudal Shah case, Rudal Shah versus State of Bihar, evolved the concept of compensatory jurisprudence and held that where rights of individual is violated by the representative of the state government, victim must be compensated. Victim must be awarded compensation for what? For the wrong committed by the representative of the state. So, where state has failed to protect the life or limb of his citizen, state must be held responsible for that. And even in Rudal Shah case, what happened? If Rudal Shah, who was to be released in 1968, he remained in jail for more than 14 years, who was at fault? Supreme Court said that jail authorities, representative of the state, they were at the fault. So, that is why state government should be held liable for that wrong committed by the representative of the state. So, this right to live dignity, right to live with dignity would be incomplete unless poor people are allowed to get financial assistance from the government, or if a person who is unable to engage a counsel due to poverty, government should come forward. If individual has committed any crime, if individual has violated fundamental rights, then that wrongdoer must be compelled to provide compensation to the victim of crime. What actually happened in Bodhisattva Gautam versus Subhra Chakravarti, I would like to discuss the facts of this case, so that you can get entire information about Bodhisattva Gautam versus Subhra Chakravarti. In this case, Bodhisattva Gautam, who was a lecturer in Kerala, and he made a promise to Subhra Chakravarti that he would marry, and due to that false promise, Subhra Chakravarti, she started living with Bodhisattva Gautam. They lived together for several years, but due to some problem, he would not live with her because he was not willing to live. So, then respondent being aggrieved, she filed a case against Bodhisattva Gautam for committing rape. In making false promise, he established sexual relationship with Subhra Chakravarti with wrong promise, with false promise. So, when matter comes before the court, Supreme Court for the first time held that even in case of rape victim is entitled to get interim compensation from the wrongdoer. So, this is the first case. This case was decided by Supreme Court in 1996, and Supreme Court held that even rape victim is entitled to get interim compensation from her husband who has committed rape against his wife. So, interim compensation is a fundamental right. She can claim as a matter of right till the disposal of that case she is entitled to get. So, you see how this restorative justice was recognized by Supreme Court, and the purpose, you see, the purpose of compensation is to provide financial assistance to the victim of crime, to provide financial assistance to that family who has lost his brother, father, who was the sole breadwinner. If a family who has lost his father or mother, who was the sole breadwinner, then it is the duty of state. It would be presumed that state has failed to protect life or limb of its citizen. So, that is why on that presumption state will have to come forward and state has to provide compensation to the dependent of the deceased. So, this is all about your right to compensation. The thing which I wanted to justify, that these are the emerging issues of human rights, and Supreme Court has played a vital role in recognizing these rights as a human rights, these rights as a fundamental rights under Article 21 of the Indian Constitution. And most important thing is that Supreme Court has also held that right to have pollution free water is a fundamental right. A person who is paying water tax is deprived from getting pollution free water, though then it would be violation of his right guaranteed under Article 20 of the right to life. Does not mean animal existence. Right to life means right to live with human dignity. So, where municipal corporation is collecting water tax and municipal corporation has failed to provide pollution free water to its local resident, then it would be violation of fundamental right guaranteed under Article 21 of the Indian Constitution. So, you just look on your screen. I just want to write one case so that you can. The name of that case is Subhas Kumar. Subhas Kumar versus State of Bihar. State of Bihar, where Supreme Court for the first time held that right to have pollution free water is a fundamental right under Article 21. So, you see how Supreme Court has recognized that it is fundamental right of citizen of this country to have pollution free water from the authority concerned, and authority concerned is constitutionally bound to provide pollution free water to the citizen of this country, so that life of the people can be saved. So, you see how these rights have been covered under Article 21 of the Indian Constitution. Apart from this, Supreme Court has played significant role in order to provide rights, in order to protect the rights of fundamental rights of the citizen of this country. One important thing which I must mention here, that is right to freedom of speech and expression, how Supreme Court has played important role in that, in recognizing that right. PUD, right to, I just want to look on your screen, I just want to mention one case which Union of India versus AFDR, Association for Democratic Right, AIR 2002 Supreme Court. This is a leading case. Union of India versus AFDR AIR 2002 Supreme Court. Three important things which you need to remember, that is, the first thing is that right to know the ground educational qualification. Second is criminal history of representative and financial status. You see how this Supreme Court for the first time held that every voter of this country has right to know the educational qualification of his representative to whom he is going to cast his vote. Every voter has right to know the criminal history of his representative to whom he is going to cast his vote. every voter of this country has right to know the financial status of his candidate to whom he is going to cast his vote, whether he is millionaire or billionaire. So, these three informations must be disclosed in affidavit, so that the representative, so that that person who has given false information to the authority may also be prosecuted for giving false information. So, you see how Supreme Court considered this information as essential information under Article 19(1)(a) of the Indian Constitution. You all might be knowing that Article 19(1)(a) of the Indian Constitution talks about right to freedom of speech and expression. Right to freedom of speech and expression is a human right provided in Universal Declaration of Human Rights UDHR 1948, and we have also recognized right to freedom of speech and expression in our constitutional scheme, in our constitution, that is Article 19(1)(a) of the Indian Constitution. According to Article 19(1)(a), every citizen of this country has right to speak whatever he wants. Every citizen of this country has liberty to express his or her view independently, fearlessly. So, freedom of speech and expression is essential component of democracy. No democracy can survive without giving this liberty to the people of that country. So, our constitution makers, they have also given this liberty to us to express our view to the society, but we do not have liberty to speak whatever we want. We cannot abuse anybody. We cannot, in the name of freedom of speech and expression, we cannot give such kind of statement which degrades which is harmful for sovereignty or integrity of this country. This liberty is not absolute. The moment we cross the limit prescribed by the Constitution, we might be arrested and prosecuted for giving seditious speechment, for giving seditious speech. So, you see, the important thing is that every voter of this country has right to know all these three things about his representative to whom he is going to cast his vote. So, how does it play important role in strengthening Indian democracy? Can you imagine that all these three informations would be helpful in strengthening Indian democracy? Obviously, these three information would be helpful in strengthening Indian democracy. How? I would like to refer the remark made by Supreme Court in this case. You see, Supreme Court said that the moment voter has to cast his vote in favor of representative in a candidate, at that very moment he express his view in favor of that candidate to whom he is going to cast his vote. So, at that time, if the voter has idea about financial position of his candidate, if voter has idea about criminal background of his candidate or educational qualification of his candidate, whether that candidate is graduate, postgraduate or 10th fail, 10th or matric pass, if that voter has idea about educational qualification, then it would be better for him to choose best candidate for democracy. In this way, every voter of this country can choose best candidate for this country, and if best candidates representatives are chosen by people, then India would be automatically become a world power, would become a developed country without once the criminals are debarred, once the criminals are prohibited to enter into the pious premises of this democracy parliament, at that very moment we would be able to establish India as a big country, India as a developed country and Vishwaguru. So, in this way, after incorporating all these three things, we can improve our democracy. So, for that reason, Supreme Court, considering the gravity of Indian politics and in order to decriminalize the politics, in order to prevent the criminals so that they cannot enter in the politics, Supreme Court has played vital role in this regard. So, this responsibility was taken by AFDR, Association for Democratic Reform, AFDR, Association for Democratic Reform. This is an NGO, and Association for Democratic Reform took this responsibility and filed a petition in Supreme Court that Supreme Court should take appropriate. So, Supreme Court accepted the plea of that AFDR, Association for Democratic Right, and Supreme Court held that now time has come to recognize this right as a essential component of Article 19(1)(a) of the Indian Constitution. So, since then this right to every voter has right to know educational qualification, criminal history and educational history, educational status of his candidates to whom he is going to cast his vote. So, definitely we can say that this is a big achievement, this is a great achievement for Indian democracy, and this is a great achievement for Indian judiciary, and thanks to Supreme Court which has recognized this right as essential component of right to freedom of speech and expression. Another important aspect of this judicial pronouncement is, you might have seen that since 2002, every candidate who is going to contest panchayat election or member of parliament, all the representatives, all the candidates, they have to furnish these three informations through their affidavit. If anything is found misleading, incorrect, that person can be prosecuted and convicted for crime, that is giving false evidence is a crime and that is punishable under Indian Penal Code. So, this is the purpose of this judicial pronouncement, and Supreme Court said that every voter has right to know all these things about his candidates. At the same time, it is legal duty of each and every candidate who is going to contest election to furnish all these informations through affidavit. So, we can say that these are the areas where Supreme Court has intervened, and we can say that these are the rights which have emerged as a human right in our legal system. So, I have highlighted each and every aspect of right to life, Article 21 of the Indian Constitution, so that you can get entire information about emerging human rights, and how you see how PIL has played important role in recognition of these rights. So, I will discuss in coming session how public interest litigation has been considered as effective means. So, apart from this, there are some other areas where Supreme Court has intervened, and rights have been recognized by the judiciary as important or essential component of right to life or personal liberty. You see, this Supreme Court for the first time held that right to shelter, not only right to shelter as a fundamental right, but whatever things are necessary to make life better must be included within ambit of Article 21 of the Indian Constitution. So, justice delayed is justice denied, denial of justice. If people are not getting justice within time, so it would be a denial of justice. So, for that purpose Supreme Court held that right to speedy trial is essential component of fundamental right. Every person has right to live with dignity, and Article 21 says that no person shall be deprived of his life or personal liberty except procedure established by law. So, suppose if a person who has committed any crime, who has breached the law, And suppose if the person who has breached the law and the punishment is 1 year, the maximum punishment is say 3 years, but that person who has breached the law is languishing in jail for more than 3 years, more than 5 years. So, it would be violation of article 21 because he has spent more period in jail which was not required by the law. The required period in the statute is 3 years, and he is in jail, he is languishing in jail for more than 5 years. So, it would be violation of his right guaranteed under article 21. Supreme Court in Hussain Ara Khatun versus State of Bihar, EIR 1979, Supreme Court held that right to speedy justice is essential component, right to speedy trial is essential component of fair trial, essential component of right to life or personal liberty. Justice delayed is justice denied if trial is not completed within time, if undue delay is caused on the part of the investigating agency, if undue delay is caused by the prosecution, it would be injustice on the part of the government. So, right to speedy trial is essential component of right to life or personal liberty. So, requires that justice delayed is justice denied. So, matter must be expeditiously disposed of. In this way, right to speedy trial has become fundamental right under article 21 of the Indian Constitution. So, these are certain fundamental rights, these are the emerging issues of human rights where Supreme Court has played a vital role, and I think I have covered each and every aspect of human right where Supreme Court has widened the scope of article 21 of the Indian Constitution, right from right to food, right to shelter, right to medical aid, right to free legal aid, right to speedy trial, all the fundamental rights, all the basic rights which Supreme Court has evolved, right to compensation. I think that is a great achievement for our judicial system, and we I do believe that if you all have understood the things which I have discussed in this lecture, if you remember all these things, I do believe that you can get success in any examination, whether it is PCSJ examination, civil examination, IS examination. With this, I would like to conclude this lecture. Thank you all.
Hi, my name is Gillette Sam and I teach sociology at IIT Kanpur. Today I am going to tell you about the different characteristics of the movement of things around the world that are associated with globalization. We refer to these kind of movements as global flows. Now, the concept of global flows is quite important, and it's important for us to understand the different ways in which these flows might occur. Now, typically, when people talk about the movement of things from one place to another in the context of globalization, they're under the misconception that things tend to flow from abroad into the place where they are living. In a very sort of stereotypical manner, there is this idea that with globalization, much of the movement that occurs is from Western countries into non-Western countries. Now, as sociologists, we know that actually global flows are multidirectional. So, which means that as much as there is a movement of flows from Western countries into non-Western countries, there is an equal amount of movement of flows from one non-Western country to another non-Western country, and in fact a movement of flows from non-Western countries into Western countries as well. Let's take the example of food, for instance. You may be aware of a type of food which originated actually in China and then goes on to Japan, called ramen. For instance, the popular brand Top Ramen that is consumed in India is an example of ramen. Now, ramen, initially the movement is from China, which is a non-Western country, to Japan, which is another non-Western country. From Japan, this very popular food item travels to Western countries such as the US and also more recently to countries in Europe. So there you have a movement from a non-Western country to a Western country. And in fact, now we have very specific types of ramen being consumed in metropolitan centers in India as well. So there's another movement from a Western country to a non-Western country, which is India. So global flows in that sense are multidirectional. A second aspect of global flows is that they could be interconnected. An easy way to think about this would be if you have relatives who are traveling from the US or the UK or Australia, very often you'll see that people request them to carry electronic items with them. They say, oh, can you please get me a laptop, or can you please get me the specific camera lens that I'm looking for. So here you see that the movement of people, which is a person moving from one country to another country, is connected to the movement of technological items as well. So global flows in that sense are interconnected with each other. A third characteristic of global flows is that we could see that they happen in reverse. In fact, they are called reverse global flows. An example of a reverse global flow would be a style of music that you may be very well acquainted with, which is Bhangra. Now, Bhangra music is something that originated, as we know, in the state of Punjab. Now, as you know, Punjab is also a state which has seen a lot of out-migration, not only to other parts of India, but also to other parts of the world. So as people migrated to other parts of the world, they took their music with them. So when people migrated from Punjab to the UK, for instance, they hung on to the music that they were familiar with. So Bhangra moved from little villages in Punjab to the major cities where people from Punjab settled to in the UK. While in the UK, over subsequent generations, this music was transformed. It was not only performed in its original version, but it was also performed with the addition of many different types of beats, which are more familiar to people in the UK. At one point in time, you see that this modified form of Bhangra comes back to India. We're talking about the 1990s to the 2000s. So here you see that that a form of music that originated in India moves out of India to the UK. It is modified a little and then comes back to become extremely popular in India again. So in some ways, this form of music is returning to where it started out, but in a slightly changed manner. We call this kind of movement as a reverse flow.